First of all, welcome to all of you. We are a little bit late because you know that we are dealing with a technology that is not in our hand, and most of the times we cannot, really predict what is going to happen with the technology. And we are waiting for Dr. K.S. Chalam to connect, and hopefully he will be able to connect very soon. But meanwhile, we have our very important guest today, Dr. Sumit Baudh, who is going to talk to us about the reservation policy and the things that come up with. He is a very, I would say, an erudite scholar who has been working on a lot of legal issues for a long time. And if we just glance through his profile, I will read a little bit of our Dr. Sumit's bio, so that we can understand the kind of the length and breadth of studies that Dr. Sumit has been through and what he's doing. He is now working with what is called the Jindal University, and he is working at the center. He is actually the executive director of a center on public law and jurisprudence, and he is associate professor. And he was formerly a British Clevening scholar, having held prestigious fellowships positions at the Center for Intersectionality and Social Policies. He was also associated with Columbia Law School, where he worked on, as a fellow in the Transnational Law Institute. He was associated with King's College London, University of California Human Rights Forum Fellowship, Michael D. Palm Fellow of William Institute, University of California, Los Angeles, and School of Law. And most remarkably, this degree is not easy to acquire. And through a very prestigious law school called the UCLA School of Law, our brother received his doctorate in the juridical science, which is called JD, and it's like a very coveted sort of a degree. And he's qualified to practice as an advocate in the courts of India. He has been writing widely on the issues of law, human rights, caste, and gender and sexuality. He's also independent consultant who has been advising the national and the international organizations and the US-based foundation, United Nations development programs, Commonwealth. I can go on and on talking about Dr. Sumit Baudh here, but also one of the roles that he has done upon himself is very important. And today is a very interesting day that we have this event on reservation. Today is also the day. It's an international day against homophobia and transphobia. This day is very important because we know that there are a lot of prejudices in the society where people try to judge and put their cultural sort of upbringing, trying to thrust them upon the other people. Sumit is one of the very interesting figure who has been a kind of a leading voice, to advocate these issues, bringing them up front, making, in a way he's trying to humanize the society, to be able to bring in those sort of all different diversities, all kind of sexualities that we have. It's not binary something. It's a wider spectrum, as you can see from Dr. Sumit's background. So he's also one of the leading advocates of country to pitch for, to praise for the rights of the people who particularly we call it LGBT issues. So without taking much time, I would like to welcome my dear brother Dr. Sumit Baudh. Sumit Baudh, welcome, and Jai Bhim, brother.
Thank you so much, Mangesh Bhai. It is a pleasure and honor to gain your personal acquaintance, to be on this forum, incredibly precious forum that you have created, the Dr. B.R. Ambedkar Caravan Facebook page. Just looking at some of your previous work fills my heart with pride and inspiration. It is such a crucial resource for our community, for students, and beyond being a resource, it is an incredibly inspiring platform to be on. So thank you so very much for having me join you in one of these sessions. I also want to say thanks to the Pan-India Ambedkarite Law Students Forum, incredible work that this forum is doing to set aside the kind of isolation that some of us can sometimes go through on campuses without any infrastructure support that campuses might provide. And more importantly, the kind of invisibilities and erasures that are imposed on the lives of students enrolled in the scheduled caste, scheduled tribe, backward class categories. And it is so important that that prejudice and that silencing, that erasure, that invisibility is somehow tackled head on. And forums as the Pan-India Ambedkarite Law Students Forum is doing some of that crucial work. So again, my heart fills with pride and humility, and I'm so very pleased to be part of initiatives as these. I know we are waiting for Dr. Chalam to join us, so I'm just a poor replacement substitute.
No, you're a scheduled speaker, Sumit Bhai. Because you were scheduled second, but now as Professor Chala will take his time, we request you to please begin, because there are listeners who are you are very willing to listen to you, brother.
So I want to, as we speak of the incredible work that Dr. Chalam has done, some of the foundational, gauging the economic parameters of discrimination, the economics part of it, is something that Dr. Chalam and of course Mangesh Bhai is going to do a much better job of introducing Dr. Chalam. I'm just completely awed and humbled to be speaking at a same forum as somebody so accomplished and senior as Dr. Chalam. So I'm really looking forward to him joining us. And until he does, we could get started with the content that I prepared for this talk today. As we know, the topic of reservations is something which is a very deep and wide area. So deep and wide that the kind of extensive work that has happened on reservations, no one session would suffice for us to even start to summarize the depth and the breadth of the topic. And many of us who are part of the forum would have multiple insights and expertise already. So I'm not about to review and revise what we already know. And perhaps in the comments and questions session to follow, we could bring in some of the inquiries that we might have. To me, as an academic, it's always important that we connect to the moment, we connect to the current times, we connect to our surrounding circumstances, because there isn't anything more meaningful than what we might be going through in the moment. And what we are going through at the moment is a troubling, unreal, unprecedented kind of a pandemic that has affected all our lives in ways that we could not have imagined even 2 to 3 months ago when all of this was unfolding. There is a very common rhetoric that is being said. We are all in it together. And I know that some of the students on the Pan-India Ambedkarite Law Students Forum are already pointing to the caste particularity of the pandemic. The caste particularity, that is to say that the pandemic is disproportionately affecting Dalit persons. The pandemic is disproportionately affecting Adivasi persons, Bahujan persons, transgender persons, women. So when there is an acknowledgement of the kind of particularity and the kind of disproportionate impact that the pandemic is having, then can there be ways and means of deploying a constitutional law framework? Much of the constitutional law framework we know is going to be partly within the realm and domain of liberty. So pursue, and as we proceed further into this session, I want to say that I would be borrowing from the insights that we gain from our classroom settings. And typically, these classroom settings in law schools are kind of laboratories for us. We're looking out for ways in which a topic might be more appealing to students. We are looking out for what is it that interests students. We are also looking out for ways in which law school is so constituted as to sometimes replicate the very domineering and dominant forms of oppression and inequality. In that kind of a domineering, in that kind of a dominance framework of inequality that we find within law school settings, then as pedagogues, as people who are leading classroom instructions, it becomes very important for us to engage at a pedagogical level ways of addressing sometimes the opposition that there might be to addressing caste-based inequality. So then we don't come from a position of an instructor or a faculty. Rather, we come from a position of equality in which the best that we can do is raise questions for younger minds and for those younger minds to find the best of answers that possible. So when we are addressing the pandemic, when we are addressing the surrounding circumstances of lockdown within our classroom settings, especially within constitutional law, the farthest that we are able to go is liberty, is Article 19. And what we would be suggesting in this session and this part of our session today would be, can there be an invocation of equality? Can there be an invocation of equal protection? I'm going to request our hosts to please enable screen sharing at my end, because we have a PowerPoint presentation that might help us with some kind of visual aid, especially as we are going to shift through. And as we are doing that, by way of introduction, what we want to develop is a constitutional law response to the pandemic. What we want to develop is an intersectional argument of liberty and equality. And we are going to be going back into history, and at a moment of genesis of the Constitution, we are going to be borrowing from some of the articulations of Baba Sahib Ambedkar. And from there, we'll be taking a leap into contemporary times. So we will be locating ourselves in the contemporary times and then taking a leap back in history and slowly recovering some of the constitutional law perspectives, some of the constitutional law possibilities of addressing the pandemic, of addressing the unprecedented, unique kind of circumstances that we find ourselves. So as we share the screen at my end, of course, Mangesh
You
already
can.
acknowledged.
Yeah, we are ready. We are ready. You can share the screen. There is an option. You can share the screen.
So the message at my end is host disabled attendee screen sharing. I think that there is something at the settings at your end that needs to be changed that would allow for me to share my screen.
Actually, it was happening. Advanced setting options.
It's all right.
Please. You can share now. You can share. You can share.
It's happening.
Yeah. Sorry. Sorry.
No
Somebody
problem.
has disabled it. I don't know what is happening. But please go on sharing now. Yeah.
So now what we should see on our screens would be a cover page of this event. And again, before we proceed into this presentation, and this is already Mangesh Bhai acknowledged the importance and significance of the International Day Against Homophobia. And partly the installation behind me is in recognition of Pride, it is in recognition of sexual and gender diversity, and it is in the recognition of the International Day Against Homophobia and Biphobia and Transphobia. And also we want to take a moment to acknowledge the passing away of a young 21-year-old student, a queer woman who is said to have ended her own life amidst very challenging circumstances in which she had been a subject of homophobia. And as we locate ourselves in this current moment of the pandemic, and as we look to the particularity or the disproportionate kind of impact that this pandemic is having, we are going to be exploring some of the intersections of caste, sexual orientation, and gender identity. So it is not only a rhetorical kind of a marking in the beginning and then we are done. You know, that would be a bit of a lip service. What we want to do is that we want to trace some of the potentials of intersectional movement building, not only for the sake of compassionate understanding, not only for the sake of building more robust and more engaging movements, but for the potential that intersectional analysis has for a doctrinal understanding of the law. So hopefully the bigger picture of my talk today will take us to some of that intersectional possibilities of an intersectional analysis and with the acknowledgement, with the marking of International Day Against Homophobia, we are going to look to explore some of those intersectional arguments. So as we move to the main title of my presentation today, we're calling it Equal Protection from COVID-19. Because as we know, the limited ways in which the pandemic might be understood within more conservative understandings of constitutional law might at best bring it to an understanding of liberty. And with that understanding of liberty, we could perhaps look to the text of Article 19, which guarantees a range of liberties, a range of freedoms. But even a most simplistic understanding of liberty would inform us that liberty is not absolute. There are reasonable restrictions. And with those reasonable restrictions, there are doctrinal ideas of proportionality and necessity, that the state can impose reasonable restrictions on the gamut or the range of constitutional guarantees under Article 19, free speech and expression, freedom to assemble peaceably without arms, to form associations or unions. A number of these freedoms are currently curtailed. And even to anybody who might not be at all familiar with constitutional law, they may not be so much as a protest, rather an understanding that would say, yes, of course, it's completely reasonable because of the kind of demands that the pandemic has placed on us. And after all, it is for our own security. And yet, there is something about a proportionate response. There is something about judicial scrutiny scrutinizing executive action in such a way that the actions that are taken by the government then are accountable. They're accountable to the demos, they're accountable to the citizens, they're accountable via the institution of judiciary. And a critical question that is currently being posed on the judiciary is precisely this. Is the judiciary somehow reticent in performing the function that it should in keeping the executive under check? But if that is going to be the extent of our interrogation, if that is going to be the extent of our inquiry, if that is going to be the extent of our application of constitutional law, then we are perhaps deficient in the potential, in the vision that constitutional law holds. And in looking back to that vision, of course, we are looking to a speech made by Baba Saheb Ambedkar in 1949. And in this moment of genesis, we know that Dr. B.R. Ambedkar is alerting the demos to be about the fragile democracy that is going to be. And it's not just an alert. It's not just something that is ominous that Baba Sahib Ambedkar at the time is saying that, look, this democracy that we're about to enter into is somehow fragile or is somehow insecure. And what needs to be done to maintain this democracy is this, that we must hold on fast to constitutional methods. And this is quickly listed in front of us. And this is a summary from a speech that is so rich and foundational to many documents, to many decisions, to many textbooks, authors, that it would serve us well, those of us who may not be so familiar with the speech, to get their hands on a copy of the speech and read it for themselves. There is something else that Dr. Ambedkar alerts us to, which is on gratitude towards great men. And there it is to alert us that, look, this kind of blind faith, this kind of bhakti is sure to lead us to a dictatorship. So that alert is something that becomes interestingly more and more relevant in present times, as we find that there are these occasional remarks made from the judiciary in utter praise of the executive in such a way that we begin to doubt constitutional ideas of separation of powers. Some of these alerts as sticking to constitutional methods, as well as somehow being alert to this gratitude that there is to great men, of being these unquestioning followers, of offering our unconditional obedience. That is something that could be dangerous to democracy. For us to maintain democracy, therefore, we have to keep a healthy distance, and we have to be alert about this kind of an unconditional allegiance that they might be offered to any one person, because that surely is a making of dictatorship. Third point is something that we'll build on the most during this talk, which is that we must not be content with mere political democracy. What does that mean? Baba Sahib Ambedkar contrasts political democracy with social democracy. And the distinction being such that in time to come, while in a political scenario, there would be equality, that is, one person, one vote. However, in the social domain, there is going to be a wide disparity of some lives being somehow more valuable and other lives being cheap and dispensable. So, in addition to political democracy, Baba Sahib Ambedkar at the time alerts us to that political democracy will not suffice. We have to work towards social democracy. And why is it that Dr. Ambedkar is bringing this contrast between political democracy and social democracy? That partly goes to the unity or the trinity of liberty, equality, fraternity. Now, most law students, most constitutional law students get to this so-called golden triangle 30 years after this incident in a landmark decision of the Supreme Court at the time, Maneka Gandhi versus Union of India. And yet look, in the very genesis of the Constitution, we have the chairperson of the drafting committee articulating this trinity of liberty, equality, fraternity, something that the judiciary would take almost 30 years before it gets articulated in a judicial doctrine. So Baba Sahib Ambedkar was, without doubt, way ahead of his time, in which many of these constitutional aspirations, many of these constitutional visions were being laid bare for that foundational moment for those who were part of it. There is a little excerpt that we are going to bring to the attention of our viewers, which is this excerpt from the speech. And in this excerpt, I quote, "We have in India a society based on the principle of graded inequality, which we have a society in which there are some who have immense wealth as against many who live in abject poverty. On the 26th of January, 1950, we are going to enter into a life of contradictions. In politics, we will have equality, and in social and economic life, we will have inequality. This part of the speech is often, in a commonplace understanding, identified with this phrase, a life of contradiction. And I think that it is doing disservice to this quote to somehow contain it or to qualify it or to characterize it with this phrase, a life of contradictions. Because Baba Sahib Ambedkar at the time was not lamenting the life of contradiction to be, wasn't just a sad and poignant commentary on the time. Rather, Dr. B.R. Ambedkar was suggesting constitutional ways to put aside this life of contradiction, to tackle this life of contradiction, to undo inequality. And the union of Trinity of liberty, equality, and fraternity is precisely that recommendation. It's that call to undo this life of contradiction. And yet again, in 2020, we find that something that Baba Sahib Ambedkar had alerted us to in a moment of constitutional genesis is something that comes to play in the most brash way by way of the contradiction that we are witnessing of a select segment being treated more favorably, that is, those of us who are located in location outside of India have the privilege and the means of being flown in, while a wide majority of us are walking long distances, are getting caught in accidents, are dying, and are bearing the weight of the pandemic. It is that life of contradiction that this genesis of the Constitution bears witness to. With this, we get to the wording of the Constitution. Remember, the main argument that I'm going to be making in this presentation is that liberty is not the only constitutional possibility. It's not the only engagement that this pandemic ought to have with the Constitution. Rather, there needs to be a union of the union of Trinity by way of equality, liberty, and fraternity. So, starting on that note of equality, we look to the text of Article 14, which is the equality before law, that state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. When we start our studies of Article 14 in constitutional law, often we try to highlight the difference between equality before the law and equal protection of the laws. Somehow our attention remains to equality before the law and what remains relatively underexplored, not only in our classroom settings, but even somehow in a doctrinal application of Article 14, there has somehow been lesser attention to equal protection of the law. So we know textbook understanding of Article 14, equality before the law is borrowed from a common law understanding, and equal protection of the laws is borrowed from an American constitutional law understanding. That doesn't suffice for us to unpack what the profound differences that there are between equality before the law and equal protection of the laws. And with a kind of a limited understanding of Article 14, what has resulted is that Article 14 is mostly limited to a due process clause, in which this equality before the law has resulted in two things. One is a classification doctrine, which mostly results in formal equality, and the other is the doctrine of arbitrariness, which allows the judiciary at its origin to scrutinize executive action, and over time has included both procedural due process and substantive due process. These are leaps of development and advancement of constitutional law, and it is not to undermine the significance of equality before the law. But what we want to bring attention to, especially for the purposes of this session, is equal protection of the laws. And since this is a phrase that is borrowed from the American Constitution, it would be worth our while to look to the wording of the 14th Amendment. And here we want to look more selectively to the latter part of this wording, which is taking us to nor shall any state deprive, look to the text which is appearing underlined and bold, nor shall any state deprive any person of life, liberty, or property without due process of law, and hence this is a due process clause, nor deny to any person within its jurisdiction the equal protection of the laws. look again, when we look to this text, we've provided some text in bold, which is going to bring our attention to liberty, equal protection of the laws. In the 14th Amendment, therefore, there is a combined operation of liberty and equal protection, such that doctrinally sometimes it becomes ambiguous whether the outcome of a judicial application is an application of what is called the Liberty Clause, or it is an application of equal protection of the laws. Here, I just want to pause a moment because this is an example that we use in our classroom settings, which hopefully remains with our understanding of the student as to what is this equal protection. We know that 14th Amendment followed the 13th Amendment, which was abolition of slavery. At the time, it wasn't known that abolition of slavery somehow will not suffice. Because what did abolition of slavery achieve, if only in paper? Because in practice, what was happening was that the former slaves were unable to leave the farms because the farm owners were standing at the gate with guns, shooting them, and the sheriff were not protecting them. So the demand for equal protection that emerged in 14th Amendment is precisely in recognition of the equal protection of laws that must be given to all citizens. So that equal protection, say by way of sheriff, is not only for the white constituency, but that sheriff ought to act for the protection of the newly liberated constituency as former slaves. When we take that understanding of equal protection, we know that there is a positive obligation on the part of the state to do something, to undo the kind of pervasive systemic inequality that there is. That then becomes the root of reservation. So we know the topic today is, we are going to be talking about laws and policies of reservations in India. Often when we talk about that, we go straight to Article 15.4, Article 16.4, and then we have these extended discussions of whether Article 15.4 and 16.4 are exceptions or proviso to the respective 15.1 and 16.1. There is something in equal protection which requires the state to take, which imposes a positive obligation on the part of the state to undo systemic, pervasive forms of inequality. So when we are locating reservations, we are locating it within the sequential arrangement of equality provisions, and we are locating it right at the start in Article 14. I just want to pause here and check with Mangesh Bhai on our time, because the way in which we had formatted our sessions was such that we would have about 20-25 minutes per speaker. And I don't want to take away all of the time such that Dr. Chalam is going to be devoid of time.
Sumit bhai, we are doing very fine on time. You please go on, because we this is very interesting presentation. We are trying to get Dr. Chalam inside. There is some technical glitch,
Okay.
and you please go on with your presentation, because it's so important that the way you are putting it up.
Okay.
Kindly go forward. Kindly go forward.
Thank you so much. Thank you so much.
Welcome.
So, as we located ourselves in the genesis, when we discussed the speech by Chairperson of the Drafting Committee, Baba Saheb Bhimrao Ambedkar, and with that, we took a leap across time, again, much back in time, when we look to the 14th Amendment and we know the historic origin of equal protection and how this equal protection then becomes the main plank or the doctrinal justification for reservations. We want to now leap forward in time and look to some of the more recent scholarship, as that of Kalpana Kannabiran, in a book project called Tools of Justice. So this is from 2012, and here is what the book jacket looks like. We're only just borrowing some select excerpts from the introduction, and in a moment we are going to say why we are doing this. In the introduction of this book project, the author Kalpana Kannabiran is discussing liberty. And when there is a discussion of liberty, the author tells us that, look, it is the denial of liberty that inaugurates discrimination. That is to say what? That when there is the systemic infliction or the systemic curtailment of liberty, that curtailment of liberty is what is able to secure discrimination. People are not naturally subordinated. People don't comply to domination being thrust on them. People comply to domination for the fear of systemic reprisal, for the fear of systemic violence. Whether or not there is any opposition to this domineering systemic inequality, there are frequent performances of violence. Those frequent performances of violence are performed precisely to secure the subject of discrimination. So, even the slightest, most pettiest incidents can result in drastic spectacles of violence. And those spectacles of violence are delivered because somehow that system of inequality and discrimination has to be secured. So this denial of liberty inaugurates discrimination. And with that, the author tells us that the courts have paid little attention to the complex interconnections between what? Between discrimination and the denial of liberty. And with that, the author is going to make the linkages, interlinkages between non-discrimination in Article 15 and liberty in Article 21. Something similar to what we are trying to do by way of extending our constitutional law understanding within the confines of 19 to beyond, to equality and non-discrimination. So with this kind of a linkage to intersectional jurisprudence that allows us to read Article 15 and 21 in a combined sort of way, it is that intersectional jurisprudence that is more transformative and is something that is in line with the constitutional vision, even of at the genesis, with the kind of union of the Trinity that Baba Sahib Ambedkar had talked about, making linkages between liberty, equality, and fraternity. Part of this book project is trying to do that interlinkage between non-discrimination in Article 15 and life and liberty in Article 21. Let's look at the text of Article 15. Many of us would already be familiar with this text of Article 15. We know that it prohibits discrimination on the grounds of religion, race, caste, sex, or place of birth. And we know that Article 15 is often given as an example of the Constitution of India providing for both vertical equality and horizontal equality. That is to say what? That it's not only the state that is accountable to ensure that is accountable against non-discrimination. Rather, even private parties are accountable toward non-discrimination. So even private parties can be held accountable to fulfill this promise, this constitutional obligation of non-discrimination. Much of this horizontal equality, horizontal non-discrimination is available to us for our reading in Article 15, Clause 2, and many of us can read it in our own time. We do want to bring attention to subclauses 3 and 4, because by way of special provisions, what Article 15 does is it allows for special provision for women and children in 15.3, special provisions for advancement of socially educationally backward classes of citizens, or for the scheduled caste and scheduled tribe. 15.4 is often the starting of our understanding of reservations, and we've tried to put aside that understanding. So we've begun with 14, we are moving to 15, and with that, we're looking to 15.3, and we are looking to the possibility of the state to provide these, to make these special provision for who? For women and children, and for socially educationally backward classes, and for the SC and the ST. We might pause here and ask, are these special provisions somehow limited to the sites of reservations that are known to us, such as that of education, such as that of employment, such as that of legislative assembly, such as that of Gram Panchayat? Is the reservations, the realm of reservation somehow so limited that it can only be this? No. 15.3 and 4 are much beyond. They allow the possibility of special provisions, a range of special provisions, and there's absolutely no containment on the kinds of provisions that can be provided. Eventually, we're going to be moving to question, are these provisions, and therefore are these discretionary provisions, or are these provisions justiciable? That is to say, that can there be a demand for the fulfillment of the creation of these special provisions, or is it only and only entirely a matter of discretion? And we're going to get to that, but it is important for us to locate some of these constitutional underpinnings of what we understand as reservations, especially as we are going to try and apply this to the current moment of the pandemic. Back to our book project authored by Kalpana Kannabiran of 2012, Tools of Justice. And in this part, the author is giving us an incident from Andhra Pradesh. I thought that this might be a relevant bit for us to include, especially because Dr. Chalam is going to be joining us. And this incident talks of a very petty incident, a very petty incident that then becomes a trigger for a massacre. And this is exactly the kind of systemic violence that the author is talking about when she was talking about denial of liberty inaugurates discrimination. So this is a petty incident over something happening in cinema. And that petty incident results in a massacre where as many as 400 dominant caste persons, they undertake a rampage of violence and kill 8 Dalit persons. And it is this massacre of Dalits in Sundur, a village in Andhra Pradesh, that then becomes one of the sites that this author interrogates and explains to us. More importantly, outside of the spectacle of violence and the deployment of criminal justice system, what the author gets to, look to the bottom of the screen, in which there is what she calls interpretive strategies. What are these interpretive strategies? These are interpretive strategies of constitutional law that would take us to more liberatory, more egalitarian potential of constitutional law. Therefore, one of the examples of this interpretive strategies that the author locates is a very famous case that is well known to all law students, Vishaka versus State of Rajasthan, in which the Supreme Court of India gives a set of directives to the state for the prevention of sexual harassment of women at workplaces. The interpretive strategy here is the understanding of hostile environment and how there is a combined operation of Articles 14, 15, 19, 21 in such a way that all of these provisions come together to provide a set of directives to the state for the prevention of sexual harassment of women at workplaces, something that was unknown at the time, something that there was a complete legal vacuum about. It could not have been imagined as in how this vacuum can be filled. And it is precisely this vacuum that the Supreme Court filled in to address a urgent crying need of the time, which is the kind of chronic experiences of sexual harassment of women at workplaces. Secondly, the interpretive strategy is of analogous grounds of how sexual orientation is analogous to the category of sex in Article 15. Both of these interpretive strategies, hostile environment at workplace and this analogous grounds, are then what allows the judiciary for a combined reading of 15 and 21. Again, I'm going to pause here and check in with our host, just in case I'm hogging too much time and somehow keeping our fellow panelist, Dr. Chalam, from joining us.
Sumit sir, please go on. We are still trying to get him.
Okay.
Please go on.
Okay. So from here, the point in which now we could, at this moment as interpretive study, we could pause and go back to Vishaka of 1997, or we could go to NAS in NAS Foundation case in 2009. Remember, this book project is located in 2012. So it could not have obviously considered the landmark decisions to follow. And what we want to bring to is something on the lines of this interpretive strategies, and also something that would tie in with something behind me, which is this intersection of caste and sexual and gender diversity. We want to bring this to the National Legal Services Authority of India versus Union of India. Because the kind of interpretive strategies that the author Kalpana Kannabiran was talking about in a book project, and bringing it to apply to landmark decisions as Vishaka and NAS, Vishaka of 1997 and NAS of 2009, We want to bring that to application to a time after the book project. The book project was in 2012. And now as we are looking to the decision in National Legal Services Authority versus Union of India of 2014. What are these interpretive strategies that the court might have engaged in this case, which is commonly referred in its acronym as NALSA? So right in the opening paragraph, the judiciary acknowledges a similarity that there is between transgender community and a constituency that is familiar to us. So look to the wording that appear on the screen, right? The second sentence in NALSA says, our society often ridicules and abuses the transgender community, and in public places like railway stations, bus stands, schools, workplaces, malls, theaters, hospitals, they are sidelined and treated as untouchables. And it is not only in the opening paragraph that the judiciary is making this analogy. Remember, the analogous grounds of sexual orientation as sex in Article 15, which was an interpretive strategy that Kalpana Kannabiran had talked about. There is something similar happening here with the analogous categories or analogous groups and identity frameworks as that of transgender community and untouchable. It would be a project in itself to uncover the intersectional potential of this case. We are not going to get into that potential. We are just saying the analogies that are being raised, and even within the limited confines of that intersectional project, look the fascinating, the fantastic outcome that there is in this court decision, because after here, we know that there is going to be an acknowledgement of Vishaka. So there is an explicit linkage that we are going to find between NALSA and Vishaka, in which NALSA of 2014 is going to acknowledge its predecessor of 1997 and recall for itself that, look, the court had deployed Article 141 to do what? To lay down the guidelines for prevention of sexual harassment of women in workplaces. With that, the court is then able to make this maneuver of providing a directive to the state to do what? To give special provisions, or what we know as affirmative action reservations for a transgender community, which is declared as socially, economically backward class of citizens. So in this select excerpt from the NALSA decision of 2014, we are seeing that TGs, here the court is saying that transgenders have also not been afforded special provisions envisaged under Article 15 for the advancement of the socially and educationally backward classes of citizens, which they are, and hence legally entitled and eligible to get the benefits of SEBC. So it is not merely rhetorical that the court in its opening paragraph is making an analogy with transgender persons, or with untouchable persons. That rhetorical maneuver has significance. It has underpinnings for what is about to happen in NALSA, because there is going to be the declaration of affirmative action and reservation, only that the court, of course, conflates caste and class in such a way that the analogy that the court makes is that of untouchables. And of course, it remains a moot point whether all transgender persons are like untouchables. But if this was a maneuver to somehow provide affirmative action, then that maneuver shifts from caste-based untouchability to what is constitutionally understood as backward classes, and therefore a class-based inequality. Anyhow, that's a finer point, and we wouldn't be, this is just flagging it. This is not the main plank that we are proceeding with this talk today. After here, the court says that the state is bound to take some affirmative action for their advancement so that the injustice done to them, to whom? To transgender persons for centuries, could be remedied. A question that we were asking is Article 15(4) a fundamental right, and is it justiciable? Then it seems that in NALSA, the court is reading Article 15(4) and making a departure from Indrasani, which had placed it within the domain of the executive to identify backwardness and to devise affirmative action reservations on the executive. In NALSA, the court is doing that. It is not the executive that is determining transgender persons as backward classes. It is the court that is doing that, and it is the court that is then, by way of a directive, advising the state to provide affirmative action. We know that over time, the Transgender Persons Act of 2019, that affirmative action is not going to be made available. But as we are looking to constitutional law, as we are looking to judicial powers, as we are looking to the current moment and trying to uncover our understanding of reservations, to relate that understanding to ways and means in which the state can provide protection, can provide provisions that would be as not just something that state ought to do as a matter of welfare mechanism. Rather, the state is constitutionally bound to undertake these measures, measures which are affirmative measures for the protection of migrant laborers, for the protection of, because after all, what is the constituency of migrant laborers? Is there, what is the caste and class? And this is something that we were really hoping to gain insights from Dr. Chalam as to ways in which these constituencies are gauged on parameters that allow us insights into their composition of caste and class. So if the migrant workers are predominantly scheduled caste, scheduled tribe, backward classes, then there is a constitutional obligation on the part of the state to make sure that there is protection available, that there is equal protection against COVID-19, not only to those of us who might be located abroad, but more so to those who might find themselves in the categories of scheduled caste, scheduled tribe, backward classes, because there is a constitutional guarantee. And that constitutional guarantee, apparently by way of our study of NLSA, is not a discretion of the state. It is something that is justiciable, because Article 141, what allowed the court to devise a set of guidelines, Vishaka guidelines, in the circumstances of a vacuum, that allowed the state to give directives in NLSA in the circumstances of vacuum, could be such that the judiciary could make more productive interventions in the scenario that we are finding ourselves. So therefore, toward as we advance with the case, we know that the court rules, we are inclined to give various directions to safeguard the constitutional rights of the members of TG community. With this, we get back to the genesis, which is the speech by Baba Sahib Ambedkar in 1949, and the part that we had brought our attention to was this trinity of equality, liberty, and fraternity. Because as we are looking to this constituency of migrant labor, as we are looking to the constituency of domestic violence experienced by women, as we are looking to the constituency of transgender persons, is there not a disparate impact? And once we recognize that there is a disparate impact on protected categories, constitutionally protected categories, that disparate impact then becomes a subject matter of equality and non-discrimination, not just liberty. Therefore, an application only just of Article 19 and even the more critical applications as that of proportionality, as that of necessity will not suffice. Rather, it would be strengthened for us to have an interconnected reading of liberty with equality, because what is apparent to everybody's commonplace understanding is that, look, this isn't fair, this isn't equal, there is something deeply unequal happening here. There is a disparate impact on a set of people who are rendered more vulnerable than others. Then if it is that disparate impact, we know that disparate impact is one of the factors of anti-discrimination. Therefore, equality and non-discrimination must swing into action to undo that kind of disparate impact. Even as we remain limited to the site of liberty, we know that Maneka Gandhi provided for procedural due process with a combined application of 14, 19, and 21. We know that 19 and 21 would not have sufficed. Therefore, for Maneka Gandhi to make this maneuver in which procedural due process became possible, in which doctrine of arbitrariness came about, it was made possible by way of this triangle, by way of this golden triangle of 14, 19, and 21. This procedural due process over time has advanced to a substantive due process. Therefore, procedure established by law in Article 21 is not just any procedure. And even if it is not executive action, if it is legislative action, even that legislative action becomes a matter of judicial scrutiny under substantive due process. All of these stunning doctrinal maneuvers, all of these stunning doctrinal accomplishments are possible because the court is deploying certain interpretive strategies, that is reading and interconnected reading of constitutional provisions that might appear to be disparate. And lastly, it is said that judiciary is being highly deferential to the executive, in which most of these cases that are being taken up, that are being petitioned in the court is merely deferring to the executive. And could that be a kind of bhakti, something that Baba Sahib and Ambedkar had alerted us to, that look, this kind of unconditional obedience is counterproductive to democracy. And if that be so, would that not be a breach of what we understand as one of the core aspects of constitutionalism, as that of separation of powers, that the judiciary is somehow abstaining from its constitutional obligation and allowing a free rein to? As we look to these sites of constitutional possibilities of equal protection, then we are going beyond liberty, and we are invoking the trinity of liberty, equality, and fraternity. And given the constraints of time, given the kind of self-restraint that the judiciary has placed on itself, should not keep us from demanding that there be a robust compliance with the Constitution, with ideals of the constitutionalism, because demos, people, citizens are the ultimate stakeholders. And if these institutions are going to somehow fail us, then it is incumbent upon us, the demos, the citizens, to hold institutions to accountability. And even if there is a recurring denial, we need to hold the institutions accountable. We need to mobilize ourselves, as we are doing through forums as these. We need to generate awareness. We need to generate consciousness, and we need to keep demanding this kind of a compliance with constitutional ideas, constitutional rights, and constitutionalism. So with that, I'm going to bring this segment of our session to closure. I'm going to stop sharing screen, and I'm going to check back with our host organizers on ideas on proceeding further with this session.
Thank you so much, Sumit bhai. That was amazing. You know, sir has little difficulty, but I got him on the phone, and I'm going to put him on the phone so that, you know, audiences can listen to his presentation. Okay, sir, wait for a minute. Wait for a minute, sir. I will arrange that. No problem, sir. No problem, sir. You just speak on the phone, and, you know, I will connect you to the you know, your people can hear you. Okay. Okay. Sir, wait. I think this also works nicely. Hello, sir. Can you say hello?
Hello.
Yes, sir. Please speak, and people can listen.
Yes, are you able to listen to me?
Yeah.
Okay.
Yeah. Sumit bhai, is he audible?
Yes, you're audible.
Yes. I had muted myself, but I can hear Dr. Chalam. Yes, he's audible.
Okay. So, Dr. Chalam, just wait for a moment. Let me introduce you for 1 minute, and then I will introduce you to the audience, and then you can go on. Okay? You can start talking. Let me introduce you first. Okay? Yeah. People can listen to you. Okay. Let me just introduce you in 1 minute, and then you can carry on. So we are very pleased to have Dr. Chalam here. He is one of the rare personalities of the community who has really you know, dedicated his life for the scholarship in such a way to bring social transformation. He is an erudite scholar, wrote a number of books, and he is, you know, a well-known political scientist and educationalist, and he's also the former member of the UPSC, Union Public Service Commission, New Delhi. And he was also working as a vice chancellor of Dravidian University in Andhra Pradesh, and he's an economist by training, and he is also known as a founder of the academic stop college scheme in the country and was its first director. And yeah. Dr. Chalam has been also was on the planning board of the Madhya Pradesh government, and he's recipient of the Young Scientist Award way back in 1984. But one of
leave all that.
Yes, sir.
Everybody knows.
So now I request Dr. Chalam to please speak on this very important issue of reservation, and he has authored a very important book that Sumit has shown us. Sumit has shown us in the beginning. Sir, please go on.
Thank you very much, Rajasab. I'm sorry I'm not able to see all of you. I am really pleased to speak to all of you under the COVID-19. We are, in effect, meeting under the shadow of crony capitalism of Madam Sitaraman, announced a few days ago and even today, worth rupees 20 lakh crores. This crony capitalism will go to only the Brahmin Banya investors. Therefore, the future appears to be very bleak. Yet, we have been fighting and will continue to fight. Now, the topic given to me is caste-based reservations. And you all know that I have published a book in 2007 by saying caste-based reservations and human development in India. It was, in fact, based on my paper commissioned by Economics and Political Theory in 1990 on caste reservations and equality of opportunity in education. And I have also published a book, Human Development in South India, the Dravidian Marvel. Based on these important issues, I would like to put before you, most of you are well-read and erudite scholars, but the issue is that let me first start with the concept of reservation. When we are talking about reservation policy, there are two kinds of reservation policy. One is reservation policy relating to employment, the other is relating to political reservations. Within social employment-related reservations, we need to talk about the scheduled caste reservation, scheduled tribe reservation, other backward classes reservations, and women. In fact, caste-based reservation is very, very old, as old as the Rig Veda and Purusha Sukta. In the Purusha Sukta, whether it is original or maybe incorporated later to suit their conditions, it was said that there are four important functions, and the four important functions are distributed among three groups. The aliens or Aryans who came from Bactria through the Hindu Kush, the our country, they have divided the functions. And first reservation was in the form of the Varna Dharma. The Brahmin is given separate functions. They are reserved for life. For others, it's very, the Kshatriya functions and the other functions we all know. But what I'm trying to say is those who are talking against caste-based reservations should understand that the Varna system, the caste system itself, is a reservation policy designed by the aliens when they entered this country. Because there were very few, maybe around 1,000 people, because at that time the total population of India was 10 lakh members, different groups and tribes. Therefore, they have designed that. Later, in the modern period, let us come to the modern period. In the modern period, the reservations, when we are talking about reservations, started with the employment. In fact, in 1856, a a person in Dharwad at that time was a part of Bombay Presidency. In fact, Baba Sahib visited Dharwad. Later, a person has applied for a seat in the school. That has created a lot of problems. Interestingly, by that time, there was a problem. I'm just giving the evolution of the caste-based reservations in our country. Then we'll come back to the concepts and how it is being taken to the judiciary and all that later. And 1856, the Mysore Maharaja is not a Kshatriya. In fact, most of the Kshatriyas in our country, particularly South India or Western India, are not Kshatriyas. They are been given that the title, or they have their what is called method through which they used to give the Kshatriya. He was a non-Kshatriya. There was a problem in the Mysore princely state. The problem was that the Karnataka Brahmins and the Tamil Brahmins were fighting. The Tamilian Brahmins were taking away the major chunk of the opportunities, that is jobs, in the presidency. Therefore, the Kannadas complained to the king, saying that they are denied the opportunity. So he, being a very intelligent person, he said that let us divide the function. Let us introduce some kind of a reservation. So it was in 1956 in the Mysore presidency, princely state, the whole question of giving reservations or quotas to different communities within the Brahminical system was introduced. Later, in 1882, the Hunter Commission was inquiring about this. And you know that Jyotirao Phule has gone to the Hunter Commission and appealed to them, given a memorandum telling that we are paying taxes, and why you are educating the Prabhus and the granting with our money, and therefore he wanted, in fact, his the Muslims of Punjab have given a memorandum to the Hunter Commission saying that they are minorities, they are denied opportunities, and therefore in 1880, first time reservations or opportunities for Muslims were created in the British presidency, in the Madras presidency. That was the beginning. And in, you all know, 1932, Babu Maharaj started the reservation and so on. And we in the South India means the whole Western India, South India, Madras, Mysore, and the Bombay presidency were neighboring states. And therefore, Sahu Maharaj, I consider, and also Baroda Maharaj, and the non-Brahmins of South India, they were all under the tutelage of the Brahmins. They have been experiencing, and they were insulted by the Brahminical democracy at that time during the British system. Therefore, they have started what is called the Justice Party. In 1926, first time in the country, in modern India, reservations were introduced. The reservations are 100%, not 1 or 2%. Out of 14 posts, 6 posts were given to the non-Brahmin upper caste, 2 were given to the different classes, including Kshatriyas. There was only the concept of different classes, and then 2 Anglo-Indians and others, and so on. So now the issue is the same reservations continued in Madras presidency even after independence, and after the constitution was introduced. You know, the problem is that the one lady, Champakadurai Rajan, went to the court saying that she is denied an opportunity because of the implementation of the reservations, caste-based reservation. And then there was Baba Sahib was there, Periya Ramaswamy was there was violence. The Supreme Court cancelled the reservation. There was violence, and the first amendment to the Indian Constitution in 1951 came, that is 15(4) and letter 64 and so on, 16 also. This is what is called the kind of reservations caste-based reservations in employment policy is concerned. But this is why this caste-based reservation. Why? What are the other concepts available? Generally, people talk about whenever even learned scholars also use the term affirmative action. This is not affirmative action. Affirmative action is possible, implemented in those countries where there is no history of discrimination, like the US. It is only to ensure that there will not be any discrimination in future, affirmative action is implemented. There is a related term called quota. Quota is some kind of a quantity of space that is fixed. It is without reference to the population or whatever. But there is also the question of reservation. Reservation, as we see today, is certain places of position are fixed in relation to the population of the caste. That is why we can see in 15.4, I think there are several of our friends in the from the judiciary and also from the legal profession. They know about the language that they use it. In the article, it is very clearly said adequately, those who are not adequately represented. So that was again amended in 1951, and it is time and again being amended for different reasons. Now the issue is why the caste-based reservations are implemented in this country. Reservations are implemented in this country to give opportunities to those who are denied in the past opportunity. You know the whole history of our country, the literate learning. We are not illiterate. We are literate learning was not given, but we are not idiot, because we know about Ravidas, we know about Socpe, we know about several poets and intelligent people. The whole Ayurveda system itself belongs to the body. Therefore, what I am not going to do the historical part of it, but the reservations were given by the British to provide equality of opportunity, because Mahatma Phule, Baba Saheb Ambedkar, Periyar Ramswamy Nayakar, and several others appealed to the government that only select few are given opportunities in the education system, others are not given. And now we have a serious problem today. The problem is public sector. Baba wanted in states and minorities, you all know. Baba wanted in the states and minorities, public sector. The primary position should be given to the public sector. And Jawaharlal Nehru also used the 1956 Industrial Policy Revolution to give employment. Now, with this, we have started entering into the system. The Dalits have no other opportunity to enter into the mainstream society, the secular society, the society where more opportunities are available. Now, it is with the help of the reservation policy that is OBCs, women, and Adivasis are entering into the mainstream society through this process. And friends, generally, people think reservations means only employment. It's not. In fact, if you know the quantity of positions that the Dalits have received so far, you will be very shocked. If we take, for example, there used to be 1.95 crore jobs in the government, public sector, central government, state government, panchayat raj, vagera, all in by 1991 there used to be 1.95 crore jobs. Now they have been reduced to 1.75 crores. Out of the 75 crores, we should say 15%. Are you able to see me? If you are able to, hello?
No, sir, you go on, sir.
If you multiply this by 16%, it comes to around 26 lakh jobs. Class 4, Class 3, IAS, IPS, vagera. It means out of 25 crores of people, that is, we are getting only 26 lakh jobs. That means just less than 1%, just around 1%. And the whole society, the Brahminical and the Bernie semi-upper caste are jealous of this. Only 1% of the population is availing the reservation. Now, the question is, what happened to this? I think I was one of the earliest to have assessed the impact of caste-based reservation on human development. By taking into account the Andhra Pradesh data and South Indian data, I have proved that with the help of the caste-based reservation, scheduled caste, I have taken only scheduled caste, not other categories. I have developed a concept called caste-based development, caste-related development, and calculated in terms of what is called human development, and if people know, means literacy, health, and income. If the three are combined together, you will get an index of human development. That is, this started in 1990s. We are getting every year human development reports. Taking that into consideration, I have calculated that how these reservations that help the Dalits to enter into education system, and that help to some of them to get some jobs and income, and that has also helped through education, their health. I have found that between 1971-1991, there is a overall human development among the scheduled caste, just because of the fact that the reservation policy was implemented in Andhra Pradesh and other parts of the country. And later, that the human development report later published how the reservation in different parts of the country are helping. And they have given a list of countries where some kind of a reservation is being implemented. South Africa, we know. In Malaysia, Bhumiputra, in several countries, maybe 20-30 countries in the world are using the concept of some-based, group-based reservation in the world. But in our country, this has become a serious problem because once these Dalits are entering into the system in the mainstream society, particularly the Brahmin Baniyas and also the upper caste are not very happy. And as far as the OBCs are concerned, there are several problems. I think now what happened is, in fact, reservations are not given because of the judiciary, not because of the constitution. We fought for it before the constitution was implemented. We have been fighting for our share in the economy and society. Therefore, people are trying to take the problem into the judiciary and into the Supreme Court. That's not false. That's not. We have been fighting, and we should fight to say that reservations are our legitimate share in the society, and we are trying to get it. As far as OBCs are concerned, we may also talk about the OBCs, other backward classes. Friends, many people may not know the fact that there are certain castes in North India who are considered scheduled caste, but in the South India they are backward classes. For example, fishermen. For example, the Dhobis. Dhobis are 25 lakhs in Uttar Pradesh, they are scheduled caste. And in Uttar Pradesh, in Punjab, if the total population of Punjab, scheduled caste population 33%, there are several, particularly the Devas in Bihar, Devas in Jharkhand, Devas in other parts of the country considered to be scheduled caste. The scheduled caste, the 11-point formula that the British have used to consider one as a scheduled caste. Out of these 11 indicators that the British census system in 2011 followed, 6 to 7 indicators clearly say that they are above the Hindu system. The Brahmin will not go to them. They don't accept the Brahmin. The Brahmin do not go to the marriages of these people. So, using this criteria, most of the backward classes now in South India, maybe in North India, they are considered scheduled caste. I'm not telling about the scheduled caste who are among the Muslims. Many people do not know that Azran is a category among the Muslims. They are converts of scheduled caste. And I have been telling people that even the Rohingya Muslims, few hundred years ago, before they were Buddhists, they were untouchables. The Chakamas, they were untouchables. They were Buddhists. They are all now gone to some other places. So that is a different story that I don't want to get into that. But now, as far as reservations are concerned, SC, ST, OBC reservations are given. When the OBC reservation issue came, you know, the Mandal Commission. The Mandal Commission used 11 indicators, social, economic, and political. All the educational, social, and economic. These three kinds of indicators they have used. In fact, they have used income as one of the criteria to decide whether somebody is a backward class or not. But, you know, the kind of problems that arose in our country after this thing introduced to the reservation, saying that there are some rich people, some creamy layer people are there. Then the issue has gone to Supreme Court. That Reddy fellow of from Andhra Pradesh, who was given that Indra Sahani case. We look at the case. I request some of our legal profession friends to examine. See what kind of judiciary we have. There is no mention about creamy layer. There is no mention about economic criteria, either in Article 15.4 or in 16.4 or any part of the whole spirit of the Indian Constitution. It's not about the economic issues. There may be economic questions related to the direct principles of state policy in bringing socialism equality. That is different. But as far as rights are concerned, they are fundamental rights. They are fundamental rights, a part of the fundamental right. So what happened? The judge, the Indra Sahani judgment is definitely not a good judgment. The learned judge has used Article 335. You know, Article 335 is specifically mentioned only about the scheduled caste. 334, 335. If somebody is there and they look into the Constitution, 335 in which they have mentioned about the efficiency of administration. Efficiency administration to whom? When the scheduled caste are given a job, they must see that the efficiency is not affected. How can you bring Article 335 related to the scheduled caste to backward classes? No one has questioned this. And so, of course, in the academic debate, some friends have questioned this. This is a wrong judgment. Whatever it says. They have introduced creamy layer. Creamy layer, what happened to the creamy layer today? After 10% of reservations are given to the economically backward class, upper caste, because scheduled caste, scheduled tribes, Muslims, all the others are not allowed to enjoy the economically backward class status. You know the statistics of poverty in this country? Among the upper caste, poverty ratio in most of the South Indians is less than 5%. Punjab, less than 5%. Andhra Pradesh, less than 10%. Kerala, 5%. Tamil Nadu, 5%. Except in Bihar and the Bimaru state, where it is around 10 to 12%. Most of the upper castes are not poor. But remember, how this judgment, how this government has given reservations on the basis of economic criteria. The economic criteria used is 2 times the creamy layer of the OBC. For an OBC, it is 4 lakhs, but for an upper caste, it is 8 lakhs. Not 8 lakhs, 8 acres of land. This is discriminatory. This needs to be challenged. This needs to be discussed and informed to our people so that they will understand what kind of a judiciary that we have in our country. Now, my question has always been that the idea of reservation is a 20th construct. We do not want that concept to be used now. We are in a democratic polity, in democratic society, and you never have used the concept of representation. Therefore, I agree to our friends and others to see that we wanted representation, proportionate representation, not only in some, but in all other spheres of social economic life of the country. It means if we are and this problem, the problem of subcaste will also be solved, because I may mention here, interestingly, there are 28 castes among the scheduled castes who are dominant in that they have more than 10 lakh population, and the total population of these 28 castes is around 60%. For example, Forge, Ramsudra, Chamas, Mahas, Mans, Malas, and Chamas, Dubi, Badigas, Kori, all these castes are dominant castes. There is no doubt about that. So this problem will also be solved if proportionate representation is given in employment, in other aspects of the life. Therefore, I have been asking that we should use proportionate representation, not reservation. Now, friends, we have a point now. Now the government has introduced economically backward classes reservation. It means that only the poor among the population from the upper caste constitute only 10%. They have been fighting against us all the years to get the 10% reservation. Now the 10% reservation given to them, let 90% of the jobs and opportunities be given to all others. Why should they get 50% of the job but only 10% of the population in the name of efficiency? Is it not illogical, irrational? Therefore, what I am trying to say is that this 10% reservation, see the mischief. If there is a reservation, if somebody goes to the Supreme Court saying that in the promotion there is no, this reservation should not be implemented, immediately the Parliament summons and then introduce a small amendment. How many times the people amend the Constitution 16:4? How many times? Within 1 year they have amended 2 times. Is it not the responsibility of the Parliament to ask the judiciary not to interfere with the policies? Is it not the role of the Parliament? It is not the role of the government to tell the judiciary that you don't represent the society. You are constitutionally, morally, you are immoral. Ethically, you are not governed by your conscience. Because these fellows, they belong to 20 judges or even 10 judges on the larger bench. All of them belong to one community and decide the reservations of others. They are not giving any judgment. A judgment is one where a rational and a reasonable argument is provided, then only that can be called as a judgment. All the years we have seen, as far as social jurisprudence is concerned, it is simply opinion. It's simply biased opinion. And therefore, friends, you may consider the fact that these judges who are appointed by the government take a vote under Schedule 3(4) that they will be allegiance to the Constitution of India. If you look at and reflect the way in which they have bypassed the constitutional provisions, are they not liable for impeachment? They are liable for impeachment. Why the politicians are keeping quiet? Why don't they tell the judges through the Secretary of Law and Justice or some legal officers that whatever that you are doing is not correct, it is your opinion, and let there be a disciplinary action against the judge. If there is some Kanna or somebody else, a scheduled caste judge, he will take action immediately. But this is not correct. When the judges are taking and using wrong judgment, giving wrong judgment, giving what kind of what we call the biased judgment. For instance, I will give you one example, very interesting example. case of that POA in 1989 case, where two judges have nullified the arrest of the culprit. You know what they have done? The judgment? The judgment constituted 86 pages, 1,200 sentences. Out of the 1,200 sentences, 65 precedents or 800 sentences were copied. Plagiarism. And then only 5 sentences are added. Is it not mockery? Is it not a kind of what we call the data profession, which is against the constitutional objective? We know that. Judges know that. And nowadays, what kind of judiciary we have today? The judiciary today, ultimately what is happening today is that I think the legal profession should reflect on this. Recently, I think everybody knows about Mark Gallagher. He's competing equals in the a wonderful book. Recently, I published another book on the Indian legal profession. He identified only 50 people in Chennai, in Delhi, and other high courts and Supreme Court. They are making money. Billions and billions of rupees. There was no schedule caste. Maybe one or two judges, maybe now and then. But no, advocate, senior advocate. What kind of a country that we are living in? Therefore, friends, as far as reservation is concerned, it is not the question of the judiciary to decide whether reservations are to be given or not to be given. Even in the relating to the promotion, what kind of a judgment is that? 16.6 is added, and it is clearly mentioned that even in case of promotion, it is valid. How can the judge ignore it? How can the judge ignore Article 70 and give judgment by citing Article 22? What kind of a thing that are happening? Because the majority of the judiciary and the majority of the elite belong to the upper caste. They don't just care for all things. What I would ultimately say is that, friends, reservation or no reservation, we need to ask for our proportionate representation. The proportionate representation, not we are, unfortunately, most of our friends in the urban areas, those who are in the jobs, are ultimately interested only in the jobs and employment. Yes, we need it, because it's only because of us that there is some kind of a consciousness and there is some kind of a awareness among the scheduled caste and our other communities. What we wanted is, however, we have seen today, in the last 2 months, millions of scheduled castes as migrant laborers are walking distances of 500 kilometers, 300 kilometers. Majority of them either OBC or scheduled caste. Is it not the responsibility of the government to provide them the subcaste? There is a constitution that has provided them the opportunity, the constitution that has given them the promise that everyone will be provided opportunity. Right? Directly in the Article 21, right to life, right to other kinds of rights, then they never, in the 70s and 80s, Krishnaiyas and celebrities have gone. Now, the issue is that every one of us are trying to take the issue of reservation to the court, judiciary. No. Judiciary has no business to enter into the government policy, particularly policies related to social issues. They can interpret the law, what the law is saying, but it is the responsibility of the state, responsibility of the organizations to tell the government that such and such judge is giving a wrong judgment. Such and such judge is not interpreting the law as per the Constitution. In fact, misinterpreting the Constitution. Though they have taken oath on the Constitution, they are doing with the they are doing this injustice to the Constitution, and they should be given impeachment. If you can ask our members of parliament, if you ask our legislators to take this issue to the parliament and then say that in the next session, let the legislators, both in the state and in the parliament, make a law that hereafter these issues relating to reservations are barred from interference by the Supreme Court, or put it in the Schedule 9, because in the case of the Election Commission and its process, judiciary and the Supreme Court has no role. Except some nitty-gritties, they have no role. Likewise, what we should ask for today is about the banning of the Supreme Court or the judiciary to interfere with the social legislation, particularly related to Article 15.4, 16.4, or whatever. It is a shame. I am sorry to use this word. I apologize if somebody is hurt. Every time that they make some opinion in the Supreme Court, the Parliament comes and sits on amending it. Who is Parliament is supreme. And it is a responsibility of the court to, in fact, give judgment or interpret it. But in this case, particularly when we have seen some of the judges have no constitutional morality, and in their behavior after retirement, taking position ethically not. I don't want to say anything on this. Ethically, they are not committing. In these circumstances, now the country has come to such a state that scheduled castes, scheduled tribes, and backward classes, and the government limit the reservation to upper caste to 10%, leave the whole opportunity to historically disadvantaged scheduled castes, tribes, OBCs, and women. That will alone solve the problems of our country, and we have several issues that can be discussed, particularly with relating to economic opportunities. The economic opportunities, only which is the chronic capitalism. I have written on that, and my next book is coming on political economy of caste in India. I have discussed these issues there. Those who are really interested to know more about the caste-based reservations, my book Caste-Based Reservations and Human Development in India, by the State Publication 2007, Social Economy of Development in India. There are a few books that I have been writing. But as far as the reservation policy is concerned, reservation policy is not a legal issue. It is a social issue. Even I'm shocked that today what's happening to the educational institutions. From when I was in the commission, I have received a note from our friends that 19 people from the IITs of this country committed suicide. 19 people. Why it has happened? They do not want us to enter into the higher education institutions. Now what they have come, you see, 6 to 10 lakhs of upper caste are not studying in this country. They have all gone to USA, UK, Australia, and other countries. Now the educational institutions, higher education institutions in this country are dumping grounds for the scheduled caste, tribes, and backward classes. Now what is happening there? It's shocking that they have given opportunities to enter education, but knowledge is withdrawn. Knowledge is withdrawn. Nobody is able to get sufficient knowledge in the education institution. Some of our friends go there and post from USA or England somewhere that they are great people. No, there are only 1 or 2. But the majority of our scheduled castes, scheduled tribes, and backward classes children, particularly in higher education institutions, are not able to gather sufficient knowledge, and the kind of studies, the research that is being done by our people is also not up to the mark. And therefore, we should also ask for the funding of higher education institutions. Standards have to be improved, and scheduled scheduled tribes must also take interest in improving the quality of education. Also, in this context, I wanted to say this. My ultimate appeal to all of you is that, friends, the era of reservation is gone, but it is a 20th century concept. The era of proportionate representation has a value of democratic quality. We need to ask for proportionate representation not only in jobs but in all other fields. Attracting friends, that there is absolutely no problem as far as reservation in political jobs are concerned. And recently, the project government has also extended reservations for another 10 years. Have you ever seen any problem with this? Because they know that some of our people are the students. Therefore, it is not simply saying that if we come to power, we will be able to do it. No, it's not possible. We will never come to power with our 20% votes. And they always remain as the agents of the established political parties started by the upper caste. Therefore, political power is not the key. Even our social power, our unity, and our strength, and the spirit to fight, not now, but hundreds and thousands of years we have been fighting. With that, we will be able to overcome the present situation under the COVID-20 to see the kind of things that the government is doing. They totally dismantle the public sector because it is due to the public sector that scheduled caste, backward classes are entering into the employment market. They wanted to dismantle the public sector. Even if we ask for private employment in the public sector, reservations in the public sector, accept, saying that efficient. What is efficient? What is efficient? The clearest opportunities are given, it is the same purpose the input. Whatever can. Not immediately, there are also investment in the human capital. That is the efficiency. But whereas scheduled caste and other caste, the reserved caste, only the best share is there. The one important observation in the COVID, we take pride that all the doctors, most of the are scheduled caste and backward classes.
Hello? Sir, there is some problem. Sorry, there was some problem. I will wait for sir's call and we will see, because I think what he presented was something very important for our people to understand, that that Professor Dr. K.S. Chalam has written an entire book, as Sumit brother is showing us this very important book. And brother Sumit, can you speak a few words on the book?
Mic test.
Yeah. You are there.
Okay. The constitutional law work or kind of legal advocacy on reservations that relies on more abstract guarantees of fundamental rights. Abstract in the sense that there is a need for data analysis, that economic dimension that provides insights into claims of inequality, works as Professor Dr. Chalam bring those insights and make it possible to validate arguments. For example, it's not enough to make a claim of discrimination until and unless there is data, until and unless there is an economic analysis. So the works of scholars, experts as Dr. Chalam is indeed invaluable to making any constitutional law advancements, to making any legal advancements, to making any legislative advancements, judicial advancements, etc. Often there is such dearth of data, mostly because of much of the statistics being obscure. And economic analyses as caste-based reservations and human development in India recover some of the obscure information and give it meaning for us to be able to understand, for us to be able to base our demands for advocacy. Similarly, for the executive, for the government, for the legislature, to be able to take specific action to be able to fill the gap that there is on counts of inequality. Mangesh bhai, you need to unmute yourself.
I think we could get connected with Dr. Chalam, and I'm just putting my loudspeaker on because that's a very important sort of deliberation. Meanwhile, Sumit brother was updating the audience about your book and the main argument of the book, sir.
Okay.
Okay, so please go on, sir. Sumit bhai, thank you so much. Huh?
Yeah. Have you heard my lecture?
Yes. No, he is Sumit brother was explaining about your book. He is also a co-discussion today, and he's a doctorate from UCLA. He's completely devoted to understanding.
Yes.
So now you continue, sir. You continue with your you finish your presentation because you got cut in between, and then.
I have finished.
Okay. Okay.
I have finished. I think it is more than half an hour.
Yeah.
I don't know whether it was audible to our friend.
It was fully audible, sir, and people have heard you very clearly. And I'm sorry that your video couldn't be connected, but people could hear, and there is a lot of comments about you and brother Sumit's presentation. So we will discuss a little bit about like you talked about the kind of a judicial over interference in the matters that concerns the society that really concerns the huge mass of our citizens in India. And you also generated this very important concept in your book called democratic representation. So while the reservation people talk about jobs and employment and educational opportunity, but in your book, you have developed these two beautiful concepts like human development in India and the democratic representation. So some people, will be very interested to hear as to how these two planks, which support a kind of a democratization of a country, can be taken forward by the activists and the movements, and maybe how we can advocate those issues, so that we can push for the reservation, quote unquote, democratic representation, and also the human development, because these are the terms which people don't use when they talk about reservation.
Yes. I'm happy that people remember that book even 13 years or 15 years after it was published. It has received very good reviews. In fact, it was used by P.S. Krishna in the Supreme Court to defend the OBC reservation. Because I have statistically and quantitatively proved that it is because of the reservation in South India that they could achieve demographic dividend by reducing the population family planning among the lower caste. Number two, by entering into the educational system, they have gone into the civil services and also into bureaucracy, lower bureaucracy, and implement the government programs for the benefit of the lower and others also. This is one. human development, it is well known now in the academic field that human development means literacy, longevity, and income. If the three are combined together, we call composite index, it is called human development index. I have used the same three factors in relation to the scheduled caste in Andhra Pradesh and the reservations between 1971-1991. What was the situation in 1971 when the reservations were about to, in a very nascent state? And by 1991, literacy levels have increased. People have started entering into job market, and their health improved, their incomes have also improved. Then I have proved with the help of the reservation, human development made possible. And also, it is because of the reservations and the social reform movements in South India, developments have taken place in South India, and if you see the human development indexes of indices of the South India compared to other states in North India, you will definitely find that the human development index of the South Indian states is much higher. It is because of the reservation, because they have started 1926 and 1902 in Maharashtra and 1856 in Mysore. Therefore, because of these reasons, that human development can mean what kind of a society, what kind of an economy that we really wanted to have. What is the objective of the Constitution?
Right.
Why a democratic government is there? It is only to improve the quality of life of people. It is only to improve the human development of the people. And how is it possible? If you are giving, say, for example, 15 lakhs per family, deposit them the 15 lakhs per family in the each scheduled caste and backward classes. With the help of that money, they will develop. But that may be used for a productive purpose or unproductive purpose. But education, Bhartrhari has long back said that education is one that cannot be stolen. If you give education, you are giving what? If you are giving education, you are giving culture. If you are giving education, you are able to inherit the past. Therefore, education, we wanted education to be continued in the public sector. Many of our friends may not agree with me that private schools should be allowed to continue. There was I studied in a government school. Till 1990, all the schools, till SMRO introduced this mischief of economic liberalization, all education institutions were under the control of the state. If the government cannot provide free education, free health care, what for the government is there? Why should we pay taxes? Why should people struggle and produce wealth and give it to a few individuals? Now people are saying jocularly that today it is very clear Gujaratification of business. And whatever benefits, investments that are going, they're all going to them. So that is not what the Constitution really wanted. Not even the capitalist system wanted that kind of a discriminatory kind of development. What we wanted today is a democratic norm. In fact, in the 20th century, in the UK, they have introduced an institution called corporation for business. But first they started public corporation. What is the corporation? Though it is a business corporation, there will be shareholders. All the shareholders meet and make decisions. That is the democratic form of taking decisions. Therefore, who will take the decisions? The representatives of the investors. They will sit together and they make the decision. But if it is happening in the case of business, why not? In the case of social development, in the case of economic development, and even in the case of reservation. So, representation, proportionate representation is the only solution that they may raise questions that there may be small caste with 10 lakh population, 5 lakh population. How can you do it? My friend, you all know that we have computers, supercomputers. and we develop the software, they will give the figure. They will be able to do it. Therefore, the problem will be solved, subcaste bickering, internal problem, discrimination will be solved once proportionate representation is given. In fact, it is also possible to combine different castes together. Why the Malas and Mahas are considered two different categories? Why the Madigas and the Chamas are considered two different categories? They can be combined together. I'm just giving a doubt thinking.
Very
So
good.
like that, we will be able to solve the problems of our country through representation, proportionate representation.
Right. Sir, that's very nicely said. I would like to put up a question to Dr. Sumit Baudh, because, he comes from the legal background, having studied the legal theories and gone into comparative study of laws in different parts of the world. So this is a question for Dr. Sumit Baudh. Like, you are an economist who has looked at this problem from the point of view of an economist, and we have Sumit here, who has in his presentation created a kind of legal what we can say, the legal frame and legal case for representation, bringing into forth the kind of what is called the intersectionality, and these are all new developments in the legal sort of field. So Sumit brother, can you like put yourself in dialogue with what Dr. Chalam has just said, or in his presentation?
Thank you so much, Mangesh bhai. So Dr. Chalam advised recommendation on proportionate representation would be echoed in a constitutional scheme in Article 16.4 that talks about adequate representation.
Tell me later.
Yeah, I will tell you. I will write down. I will tell you. I will write down and tell you.
Okay.
Go on, Sumit brother.
And that adequacy of representation has applied to qualify backward classes and the reservations or provisions for backward classes. We know that Indira Sani had considered that idea of adequacy of representation to get to the validation of Mandal Commission implementation by the government at the time. Between Indira Sani and the Supreme Court decision of M. Nagraj to follow, there was some confusion about the applicability of creamy layer to scheduled caste categories. And the constitutional amendment made it amply clear that there can be, say, reservations in promotions for scheduled caste categories. Dr. Chalam is right that there seems to be a contestation between the judiciary and the parliament in such a way that the gains and advancements made by the parliament appear to be repeatedly constrained by judicial review. And yet it is something that is inevitable because in an understanding, in a constitutional understanding of separation of powers, and in an understanding of the basic structure doctrine, even constitutional amendments passed by the parliament are not beyond the purview of judicial review. So in M. Nagraj, some such constitutional amendments, namely Article 16, 4A, 4B, came under judicial review. And while the judiciary upheld the constitutional amendment, the outcome of that was subject to certain restrictions. So while the judiciary validated the constitutional amendment that brought in force Article 16, subclause 4A, 4B, the judiciary restricted these powers of the government by the application of ideas that were previously applicable to the category of backward classes. Therefore, if the government was to provide any scheme for reservations in promotions, then those promotions or those positions would be available or would not be available to the creamy layer within scheduled caste categories. Further, any such positions would have to fulfill the requirement of inadequacy of representation. By way of this judicial maneuver, what the judiciary did was applied a number of parameters that was previously applicable to backward classes. These were applied to scheduled caste categories as well. Something that the Supreme Court partly corrected in Ashok Kumar Thakur in clarifying in the area of reservations within educational sector that creamy layer does not apply to scheduled caste categories. And yet the outcome, the doctrinal basis of N. Nagaraj remains. But I am in agreement with Dr. Chalam that there appears to be a contestation between the parliament and the judiciary. And what appears is that the parliament is far more invested in the advancement and securing of reservations, while the judiciary appears to be more skeptical. I'll go a step further and say that the judiciary, especially in more recent times, appears to be systematically dismantling and dislodging the salience of caste. So while the National Legal Services Authority versus Union of India of 2014, a case that I discussed during the previous segment of this session, validated transgender persons as a backward class. Another Supreme Court decision of 2015 by the title Ram Singh, which had looked into the possibility of Jats being categorized as backward classes, not only denied that category of backward classes to Jats, but went a step further in saying that caste cannot be so salient, caste cannot be so decisive in gauging inequality. That was damaging to the salience of caste to inequality. It wasn't just about the question of Jats and backwardness, because if that was the question, the court could have well just come to a finding that the backward class category is inapplicable to Jats as a caste group. But the Supreme Court goes beyond that and says that the salience of caste to inequality is dated, it's a thing of the past. And now somehow we need to be looking to new emerging groups as transgender persons. The court didn't have to set up competition between caste and gender variance. And it appears that in Ram Singh, the court set up a zero-sum game. That is to say that only the loss of one can result in gain of another. These kinds of maneuvers are very unbecoming. It is unbecoming because they needlessly set disadvantaged segments at competition with each other. And especially today, as we are commemorating International Day against homophobia and transphobia, we do want to call out state power that advertently or inadvertently posits disadvantaged groups in competition with one another and is divisive of any intersectional possibilities of movement, people coming together.
Right. Chalam sir, can you could you get anything of?
No, I could follow. I'm sorry.
Okay. I will just try to summarize. I'm not good in summary, but because of this legal technical.
Okay. What was his main point?
Sumit, brother's main point was that your basic premise is right, that there is a tension between parliament and judiciary, and that the courts have been like going unnecessarily in terms of diluting the caste and saying that it's a relic of the past, and we need to have it's like it's not applicable today, and in a way through their judgments cited by brother Sumit, like Ram Singh case, and like diluting this kind of the importance of caste. And he's also arguing, saying that the court in a way sort of creating the competition between the different marginalized groups, like like transgenders, the JATs, and the scheduled caste, and so on and so forth. So he's saying that in a way, this kind of over interference into the social matter of paramount importance for the constitution has been, very unmindfully treated by the judiciary. Is that what, Sumit bhai, am I summarizing rightly?
Yes, yes. Thank you so much, Angit. Absolutely.
And Sumit has also been saying that those things which were applicable for the OBCs have been unnecessarily put on the scheduled caste, like creamy layer, and
Yes.
all these technical things have been brought into the reservation in promotion, like adequate representation and creamy layer in the promotion. So he thinks that there is a kind of no coherence between the constitution and its goals and articles. He says that the constitution authorizes the judiciary to go for the judicial review, but
exactly. That's yes.
Yeah.
Totally agree with you.
So
Wow.
but but it's overstepping its boundaries and going into the social sort of field, and it's unnecessarily creating tensions among the communities. So on this comment of brother Sumit Baudh, sir, any last comment from you, sir?
Yes. In fact, he has complimented, he supplemented whatever I have said. Professor Subodh, nice talking to you. Really, now the issue is the Indian judiciary is not representative. Unlike in other countries where they are elected, in some countries they are nominated from different groups. Indian judiciary is not at all a representative judiciary. They have no moral right or even constitutional morality to give judgment on social issues when none of the categories or groups they are giving judgment are represented in the bench. This is one legal and theoretical and moral question. And the other issue is that we should now have a very interesting kind of a tool in our hands. Modi Bhai has recently said that any contract more than 200 rupees contract will not be given to outsiders. Now what my contention is that we are talking about what is called the efficient representation. Now we will say simply that you give all the economic opportunities to the scheduled caste and scheduled tribes of backward classes because they represent the proportion of the 90% of the population of the country. No more creamy. Why are you using creamy layer only for employment of scheduled caste, scheduled tribes and backward classes? Why don't you use creamy layer for the appointment of the judges, for the appointment of the secretaries, for the appointment of the contractors, for giving government what is called contracts or permissions to start business? You see, this cannot be a partial kind of a thing. If you consider that creamy layer is a principle to be used while distributing resources of the government or the common properties of the people, it should be applied to all. While giving contracts, while permitting mining, while giving defense contracts, while giving appointing the Supreme Court judges, High Court judges, why don't you use the creamy layer? Why a poor Brahmin is not given an opportunity? Why a rich Brahmin? If you look at the Sumit Baudh, if you look at the history or the social background of most of the judges, in fact, Mark Garlander has given that. If you look at them, only judges' sons or the advocates' sons are becoming the judges. Why it should be? Why creamy layer be used only for scheduled caste and scheduled tribes? Use the principle of creamy layer in all spheres of life and eliminate whoever is about that. This is my appeal, and this is going to happen when we have a responsibility in educating our people. Our members of parliament and legislators do not know much about this. We should publish small booklets and conduct classes. I think you are doing it. Conduct classes and see that in the parliament, let them raise it. Let them raise that if that particular judge has given a judgment which is against the constitutional principle, he should be impeached. Let that impeachment proceedings be through a private bill be introduced. Then they will realize what the mistakes they are committing. Thank you.
I think Dr. Chalam sir, I think what happened today in this webinar is something very, very interesting which has emerged, because I posit this webinar in a very historical context, that we have a person in you who has been studying, bringing in economic theories to understand the problem of the caste-based reservation vis-a-vis, the political economy, vis-a-vis the democratic representation, vis-a-vis, what we can say, the Human Development Index on one hand, and on another hand, we had Dr. Sumit Baudh, who is a legal expert, having studied the comparative laws in different parts of the world, having exposed to the sort of the different sort of quote unquote affirmative action. This is a very narrow word to describe what is happening in India, as you have specified in your wonderful book, that given different interpretations of the word used, like quota, reservation, affirmative action policy, and how doesn't it relate to what is happening in India. It's a case of a proportionate representation. I think we had a wonderful dialogue today, and sorry.
I have one.
Please.
Submission.
Yeah, please.
Now we should say use creamy layer in all appointments.
Give creamy layer in all appointments. Yeah, that's a good point.
All appointments, including judges.
Yeah.
Creamy layer for contract.
Yeah.
Creamy layer for giving. Let them use the creamy layer.
Yeah. Why we should have double penalty? Remain backward and also have the creamy layer category.
Yes.
It's a double penalty.
Yes.
Yeah. I think they should have at least single penalty. That's true.
Yes. Why the poor Brahmin be denied opportunity? They are telling the poor scheduled castes are not given opportunity. On the rich scheduled castes are given the opportunity.
I think that's
also true in the case of the backward class, Brahmins and Baliyas also.
Yeah. That's
Let them use the creamy layer. Let them use the creamy layer.
Yeah. That's a wonderful point, and there are so many takeaways from this. What I envision in the future is that I would like to see that your talks are transcribed, because this is a wonderful transaction today, and we can, as you said, that we have to develop it into a booklet and circulate it widely. If you too agree with this proposal, then I will get somebody to transcribe both of your talks, and we develop it into a kind of a booklet, so that people at large can benefit from this interaction.
Okay, wonderful. Thank you.
So there comes Yeah, Sumit bhai. Okay. So Dr. Chalam, thank you so much for joining us today. And because even there was a technical glitch, you could make it to the webinar today. We are so grateful to you. I know you at this age, trying to talk so much for a long time, trying to convey your emotions for the issues that you feel so dear to your heart. And we are so extremely grateful as a community for joining us today. And we will invite you again when the technical things are out. We will invite you. Okay. Thank you, sir.
Thank you, everybody.
Thank you. Jai. I think we had a very long conversation today, and I think what we will do now is, I will just say a few words on Dr. Sumit Baudh's wonderful presentation. Dr. Saab, you have taken us through a very beautiful. I can't say the legal issues can be communicated so clearly and in such a language, and without adding fire, because as an activist we are trained to add fuel to the fire, but with your cool heart you could speak about the issues with such a dignity and with such a finesse that we are very, very grateful to you for joining us today. We would like to invite you more on our Ambedkar Caravan shows, and talk to the people. They are wonderful audience here, and they would like to know more about it, and we shall be extremely grateful if you can give your valuable time in the future, so that we learn a lot. And it's like a public education of a community. You you teach in the classroom, but this is a wider classroom. As you can see, it reaches our media reaches to a lot of people in their drawing rooms, and eventually we know that there are thousands of people will be looking at this, and this is recorded, this is curated, and the people can have access to what you said now in the centuries to come. Hopefully, if the world remains as it is. So, of concluding words from you before I hand it over to Dipankar. Concluding words from you, Sumit bhai.
I only just want to pass the mic to Dipankar, and before then, my gratitude and thanks to you for having a forum as this. As I said in the beginning, it is my honor and joy to be involved with public education endeavors as these. Further, as we are passing the mic to Dipankar, the value, the need for the Pan-India Ambedkarite Law Student Forum is such that it draws on my own personal investment in the movement, especially on campuses. And today, as we're using this forum to speak, sometimes it is difficult to speak in abstraction. And as we are speaking, sometimes we imagine our audience. And the audience that was imagined by me was mostly students enrolled in law school. So at times, the content of my presentation might have moved too fast from one constitutional provision to another, from one constitutional idea to another. And for that, I want to apologize to those of our audiences that might have struggled to keep up with that pace. But I do want to reach out, especially to law students. And I want to say to you that I'm personally rooting for you. I am eager to know of the successes and the accomplishments that you go on to making, and the tremendous potential power of law as a discipline is something that we all want to keep faith in and pursue our professional careers, be that as practitioners, as academics, as judges, because those are pivotal ways in which we can make our influence, in which we can play a constructive role. So with that, with sincere heartfelt gratitude, both to you, Mangesh Bhai, as to Dipankar, for setting up a platform like this. With that, over to Dipankar Kamble.
Am I audible?
Yes, Dipankar, yes.
So I had few questions, but Mangesh sir already covered those questions in his talk with Chalam sir and Professor Baudh. But so there's no much left for me to deal now. I'll directly move to vote of thanks. And it was a great talk today. And as Mangesh sir suggested, that if we could really translate these talks into manuscripts and publish now, like we have our own publishing houses like Shared Mirror and Panthers Fox. So if we could publish these talks and translation, it will be really great and will be really helpful for our students and for coming generations. So I thank Professor Baudh. He was very supportive throughout my role as a facilitator to this webinar. And even there was some technical failure from our side. We couldn't manage to get Chalam sir on the video conference, but we are sure that this technical glitches will not be repeated in future. And looking forward to more such conversation. Thank you so much. Jai Bhim.
Thank you so much, and goodbye to audience. See you at 6:30 if you want to know how to bring Ambedkarite cultural revolution in the country today. I think that's a very vital topic. With the two young Ambedkarites, we'll be talking about their cultural journey and how we can bring that kind of an explosion of cultural revolution in this country, which is very much needed today as we face the problems in our country today. Thank you so much for joining in.